Welcome to Blue Iron IP's Patent Myth podcast. I'm Russ Krajak, your host, and the author of Investing in Patents, as well as a soon-to-be-released book called Startup IP Strategy. Blue Iron provides financing for patents, so we look at startup companies and their assets, the patent assets, as having value and trying to figure out how do we create value with those assets. Our view is that 95% of all the patents out there are worthless, and the percentage might even be higher for startup companies. Our aim is to take down some of those existing patent myths and put in better practices so that startups could do a much better job with their IP. I hear it all the time from entrepreneurs. Why should I bother getting a patent? I'll never be able to enforce it. Well, in reality, you can buy patent enforcement insurance, essentially prepaid legal fees. But there's also a whole bunch of other reasons why you should have patents as a startup to help you do business deals in the future. There's a myth that startups cannot enforce their patents, so why bother? That's a widely held conception. I was going to say misconception, but for some startups, maybe that's true. So in this episode, we're going to talk about patent enforcement and defense insurance and how that actually works for a startup. We're also going to look at other reasons why patents work in the startup ecosystem. There's a really sophisticated secondary market for patents. And it's cloaked in mystery and intrigue, I guess you could say. But most of the deals that are done are, have secrecy, non-disclosure requirements and stuff. So patents might get bought and sold at different times. And we just don't know about them. But there's a lot of IP that changes hands over, in the course of the year. And it may be in the order of, approaching trillions of dollars. Okay. But we never see it. A lot of this stuff happens in small chunks where, a portfolio of 40, 50 patents are bought and sold by somebody. And it's not big enough to move the needle on some big, for a big corporation. So it never really, pops up for public knowledge. But the sophisticated patent market was, I wouldn't say it's instituted by Intellectual Ventures, but they certainly took it to a whole nother level. Back in the day when Nathan Myhrvold started Intellectual Ventures, they were buying patents like it was going out of style and spending money, and anybody that had a patent was selling it to IV, and IV had cash, and patent prices were going up, and everything was wonderful. And that, that still continues today, but in a much, much, much reduced scale, I think, from IV, but also from other people. Lot of companies grow up and figure out that patents need to happen. Microsoft had been in business for 17 years before they really figured out that, hey, we need to have patents. And so that's when Marshall Phelps joined Microsoft. He was formerly at IBM and kind of did this burn the ships mentality. He wrote a book by that name, which is really good. And he talked about that transition to an IP kind of centric, but an IP, a company that valued IP. One of my first jobs out of college was at McDonnell Douglas, and this is at the very, very tail end of the Cold War. I had this invention, and I was, 1 or 2 years out of college. I thought, wow, this is really cool. Newly minted mechanical engineer. I got this great invention. I handwrite the, I hand wrote the invention disclosure with little figures and everything, and I sent it in, and I had the chance to go visit the patent attorney. And, McDonnell Douglas we built airplanes. We built the Harrier, the Aviate. We built the F-15 and the F-18, as well as the YF-23 and the YF-22 and the Avenger 2, the A-12. I was on that program. I don't know why I should forget that. But anyway, I get to go visit the patent attorney. And this was a big thrill for me because, getting an invention, getting a patent really early on is, that would be glorious to put on my resume, because I like that kind of stuff. So anyway, I went to visit the attorney, the patent attorney. And, this was back in the day of gargantuan industry, where there was 30, 40,000 employees at this one location spread over tons of buildings. And, to give you just a sense of the amount of experience that was at that place, for a tool maker, which is one of the highest grades of machinists or, mold maker, whatever, for somebody in the tooling department to make it to first shift, to have enough seniority to make it to first shift, they had to have 25 years of seniority. Okay, 25 years, and then they can make it onto first shift. I mean, there was knowledge in this place. There was old. The place just reeked of institutional knowledge and experience, and they knew how to do things, and it was quite a fascinating place to work. Anyway, I got to go visit the patent attorney, and he was in the basement of some old forsaken factory. The basements were concrete and damp and dank and badly lit. And I find the guy's office, and he, it's an older guy with, most of the way bald, and his comb over doesn't work anymore. And he's, just old, and we all wore shirt and tie back then too, wrinkly shirt and, just stained tie, the whole 9 yards. And this is the first time I ever got to meet a patent attorney. I was fascinated by it. And I wanted to know why my invention got rejected. And, this old grizzly guy, he'd had this conversation before, okay? But he told me, out of every 10 invention disclosures we get, we file one patent application. And out of every 10 patent applications we file, we get one patent. And out of every 10 of those patents that we get, actually it might be every 100 of those patents we get, one of them is valuable, but that one that's valuable pays for all the rest. And that really, it impressed on me the, asymmetry of the returns on patents. That the one patent that's really valuable pays for all the rest. And so, it's kind of the old needle in the haystack kind of thing. But I learned from that. My next company was at Mac Store out in Colorado, and we built disk drives. And it was the polar opposite of big iron McDonnell Douglas. This is scrappy little startup, in amongst a bunch of other scrappy little startups in the disk drive business. In fact, from my desk at Mac Store, I could see two other competitors that were literally within 100 yards of us. Across the street, there was Connor Peripherals and this other place called Prairie Tech. Within the first year that I was at Mac Store, Prairie Tech went bust, and we all went over there at lunch and walked around the place and bid on, getting a computer or a desk or whatever. I mean, they just completely liquidated the thing. But the patent story is that, here's Mac Store. They're kind of a startup company. They're making some money, and Connor is a similar sized company that, we're, in the $10 million range, maybe. I don't recall exactly how big they were. But one day Connor came across the street and knocked on Mac Store's door, and they said, you guys are infringing our patents, and we have 3 of them. And Mac Store was like, whoa, wow, that's pretty serious. And so they huddled back, and then Mac Store went back across the street for another meeting. Connor had 3 patents, and Mac Store had like 10. And, they were like digging under the, digging between the seat cushions to find these things. They just happened to have them. There was no rhyme or reason for them to have them. But for whatever reason, the company had these assets. And Mac Store went across the street. Initially, Connor had said, you owe us money because you're infringing our 3 patents. And Mac Store went back with a bigger stack. And that negotiation ensued. And the net result was that Connor was going to pay us some money because our stack was bigger than their stack. And, it was $1 million, $5 million. I don't remember what it was. But the net effect was that, they thought they were going to walk away with cash in hand, and they actually wound up owing us money. So people came back across to Mac Store, and they're like, holy smokes, this patent thing works. And so they put a program in place to pay for invention disclosures, and let's get as many of those as we can in there, and let's get as many patents as we can, because now we're going to be in a race with the guy across the street. And so we were filing patents like it was going out of style. We were just filling out invention disclosures, and they were paying, they pay $100 for an invention disclosure and $1,500 or something if your patent got filed. And, they had that program going. But it also really impressed me that even small companies with small portfolios can extract some value from their assets. These kind of, what happened with Connor and Mac Store was a cross-license agreement, but it was tilted towards Mac Store's benefit. So Mac Store got access to Connor's 3 patents, and Connor paid for access to Mac Store's 10. And Connor was paying us for that. And so there was this, they lit up this big patent filing thing that went on for a while. And I left the company before, the next round of negotiations happened. But that kind of stuff actually happens with startup companies. And those interactions, Connor walking across the street and thinking that they can get some money for their 3 patents, is a typical way that companies will engage each other. Often without a whole lot of forethought. They just kind of, we got these assets and let's see what we can do with them. And then after doing it once or twice, they really start to learn. And, and then they go on, once burned, they'll really put the effort in to do it differently the next time. There was Facebook, for example, had like 10 patents or something. And they were getting absolutely slaughtered by Yahoo, who was suing Facebook. Facebook had no patents and Yahoo had a ton of them, and Yahoo was banging on Facebook about it. And so Microsoft was able to buy a bunch of old patents. They were good patents, but they bought a bunch of patents from AOL. AOL was kind of on its decline. Microsoft put in $1 billion, bought a bunch of patents from AOL, took a license to them, and then sold a portion of those to Facebook. So Microsoft made sure they were not going to get in trouble with these patents. Then they passed them off to Facebook, and Facebook was able to use those assets to equal the playing field with Yahoo. In the same way that Connor and Maxstore, my company, kind of even the playing field with 3 or 10 patents, they're doing this at a much, much, much larger scale with Yahoo and Facebook. I had a lunch with a friend. This was a few years ago, and he was at a cell phone manufacturer, and he was involved. He was a chief patent counsel at this manufacturer, and they were involved in a lawsuit with some other company, and I don't remember if it was Kodak or Xerox or somebody. But one of the things he said was, "Oh, hey, if you find any patent that might possibly be infringed by, Kodak or Xerox, whoever they were in a lawsuit with, I want to buy that patent." And they will just buy that patent, flat outright, even though it has nothing to do with their business model. They'll buy that patent because somebody else infringes. And circling back, it's really about this idea of the enemy of my enemy is my friend. Any patent that somebody else infringes is worth money to anybody who hates that person. Anybody who is suing Xerox or Kodak or whoever was involved in that lawsuit is interested in buying the patent that Xerox or Kodak infringes, because that allows them to level the playing field. So the assets that are being created by startup companies will often fall into this category. And whether the startup company can actually enforce it or not really doesn't matter. Okay? If they can, if at the time of that lawsuit, if we could sell a patent to this company and they can use it in their lawsuit, they're happy to pay money for it. And in fact, a lot of people will rent patents for the purpose, essentially rent patents for the purpose of litigation. Like I'll get an exclusive license with a right to enforce, and I'll pay you money up front. I'll have the patent for a period of time, and I'll extract some license, or, whatever. off this other person, and maybe I'll win, maybe I don't, but you get paid nonetheless. A lot of those kind of deals actually happen in real life with real startup companies. There's other uses for having patents. If you have a patent program and you're actively creating patents as your engineers are developing new things, that is a deterrent for a competitor to poach that employee. Because first off, that when that employee walks out the door, everything that's in that employee's head is actually owned by you and already written down and protected in the form of a patent. But also when that employee shows up at the other place, that knowledge that they have, as it comes out of them, as they develop, start working for your competitor, a lot of those things, those ideas are likely to be already patented by his previous employer, by you. And so there's a lot less incentive to poach employees when a lot of patents are going on and protection is happening. Another use for a patent is in the open source space. You think, well, that's kind of weird, but it's true. If you have a patent on a product and you put it in the open source library, but you say, hey, this is, you can use this for educational purposes, but not, for-profit purposes. Well, you can enforce that with, one of those many different kind of copyrights agreements that open source has, but you can also back that up with patents where you say, you know what, if you do infringe and you're doing it for profit and you're using this code, well, that's patent infringement. So not just I'm not only going after you for copyright infringement and, violating a copyright license, I'm going after you for patent infringement as well. So that's two hammers that I get to use to go hammer, to go after somebody. But kind of the real reason why I wanted to talk about this was this enforcement and defense insurance. And this is a product that I sell. I'm an insurance broker, and I sell patent enforcement and defense insurance for startup companies, anybody who owns patents or might be subject to litigation. Enforcement insurance is where we essentially buy prepaid legal fees so that we can go out and enforce patents that we own against competitors. The enforcement insurance is really affordable. It's on the order of 1% over the amount of coverage. So $1 million of patent enforcement insurance will cost you about $10,000, less than $1,000 a month kind of thing. And that's essentially prepaid legal fees that you have at your disposal when you find some infringement and you want to go after that infringer. Send him the nasty letter, light up a lawsuit and send it to him. The fact that you have insurance means that the money's not coming out of the bottom line. It's not about draining your bank account to go after somebody. This is already prepaid. And patent lawsuits are enormously expensive. Okay? It will typically take you $500,000 to $1 million just to figure out what the patent means. Okay? And so once you figure out what the patent means, now we got to figure out, was there actual infringement and how much is that worth? And it's not inconceivable to spend $2 to $5 million on a patent lawsuit. Oh, and by the way, soon as you win or soon as you lose, you go up to the next level, the Court of Appeals for the Federal Circuit, which is the specialty appeals court for patents and other limited, they have a very limited scope, but they're specialized in patents. And they get to review the whole thing. You basically get to retry the entire case up there, and hopefully you win, or hope you whatever. So it's an expensive process, and it's not for the faint of heart, and it takes a huge amount of capital to do this. And essentially, patent litigation is turning into a big game of chicken. Well, how much money do you have, and how much money are you willing to spend? And when you have an insurance thing, you've already paid for that, and you can go to the distance. So, you can buy the right amount of insurance and away you go. The other interesting fact is that a lot of investors ask startups to get directors and officers insurance. And this is when an investor might take a board seat, for example. The investor wants the startup company to pay for D&O insurance so that anything that the investor does as a board member would be protected. They're not going to sue the directors. And so that's typical of any investor who requires that of a startup. However, for every D&O claim, for every lawsuit where D&O insurance paid out, there was 14 patent lawsuits. Okay? The likelihood that there's going to be a patent lawsuit with your company is 14 times more likely than anything involving directors and officers insurance. So anytime that an investor looks at a startup and is doing their due diligence and says, well, I don't want to get messed up in a D&O claim, and I want to make sure that the directors are protected so they can be honest and open and all that kind of stuff, there's 14 times more likely that that company is going to go through a patent litigation. The other part of patent litigation, we talked about enforcement, taking the patent to somebody else and enforcing that, and either asking them to cease and desist or to get a license or whatever. The other part is patent defense, where somebody sues you, and that could be what they call a patent troll, which is somebody who doesn't compete with you, or it could be a competitor. And in either event, a lawsuit can be crippling to the company, both in time and money especially. And are you going to be able to raise another round of investment when you've got a lawsuit, where somebody says that you're infringing their patent? Well, no. Who's going to pour money into that? There's a chance of losing, of course. But I want to talk a little. One of the examples is a company called Octane Fitness. Now, Octane Fitness was a startup company that made exercise equipment. I don't remember exactly what kind of machines they made, but like rowing equipment or weightlifting or whatever. And they got patent defense insurance, and they got it pretty early. And what happened to them was they got going. They had a round of funding, and life was good. They started making product, but they had patent defense insurance. And sure enough, a patent troll, a non-practicing entity, lit them up with a lawsuit. And what's typical practice is that, and this is why we call them patent trolls. Typical practice is they'll light up a lawsuit and they'll sue somebody. And they'll sue somebody for, less than the cost of the litigation. Or I shouldn't say they sue for that. They sue for a ton of money, but they settle for less than the cost of the litigation. So they might light up a lawsuit and then say, well, you know what, we'll settle for $500,000. And, any business owner is going to look at it and say, well, I can pay you $500,000 and I have zero risk. It's expensive, but, it'll cost me $500,000 to kick you around a little bit. And I have a very high risk that I'll still have to owe more money. So what makes sense? Well, it makes sense to just pay the extortion and move on. And so this troll had done that for a couple times, and they got to Octane Fitness and they did the same thing, light them up with a lawsuit, and then said, hey, well, we'll settle for $500,000. Well, Octane Fitness had patent defense insurance. And they're like, you know what? Let's go. Let's throw down. I'll challenge your patent. Your patent's no good. Let's go. And so Octane Fitness was able to challenge that troll, beat the living tar out of them, win in court, and their case, the Octane Fitness case, actually went all the way to the Supreme Court and all the way back down. And they lived to see another day. The happy ending is that Octane Fitness was later acquired by Nautilus Fitness Equipment for something like $100 million or something. I don't know that my numbers are 100% accurate there. So, but Octane Fitness, a startup, had patent insurance and lived to tell about it. Okay, they weren't a victim of this patent troll business. And so, when I do patent financing, I require that a startup company have patent enforcement and patent defense insurance. When I'm financing the patent, I'll pay for the enforcement insurance. And the reason is because I don't want an opportunity to go by where the startup failed to act because they didn't have the resources. Now, an opportunity may come by where somebody infringes and the startup uses that as a negotiating tool to do a joint venture, to cross-license or whatever. That's perfectly fine. But if there's an infringer and their internal rubric says we don't have money to enforce that, well, then the asset that I invested in is devalued and may be worthless because it was never enforced when it should have. If that happens, well, then that reflects badly on my investment. So that's why that's why I pay for enforcement. I also want them to have some level of defense insurance, at least a modicum of it, so that in case something happens, they have more options. Okay? I'm not saying they have to enforce it. I'm not saying they have to do anything, but I want them to have good business options and make decisions not on, fold up and go home or bet the farm or anything. I want them to have a lot more options available to them to keep the company going and try to strike a deal somehow that benefits them. And, in some of those ways that we talked about before. So, here's I'm a big fan of startups having patents. I'm a big fan of them having good patents. Okay. So I'm not a fan of having patents just for patent's sake, but the more useful, more enforceable that patent is, the stronger it is for any of these other scenarios. A badly written patent with super narrow claims, I'm never going to be able to sell it to somebody who's involved in a litigation, because nobody enforces that. I only can sell those assets. I can only trade those assets. I can only extract a license agreement from somebody when those patents are super, super good. what we call investment grade patents, where they're well written, they're well prosecuted, where they capture real economic value, where they're super detectable, and where we can prove that somebody infringes. When you have all those things, all of a sudden you've got that golden ticket that we can trade for money, we could trade for opportunity, and we can make things happen with those. So startups should get patents, and they should get patents because they can enforce them when they have some, certainly they can enforce them directly when they have insurance for that. But even if they don't have insurance, if they have super high quality assets, they're worth money to somebody. And we can usually trade for that or sell them off or whatever. We have a negotiating tool when we have really good assets. Well, thanks for listening. I'm Russ Krajak, CEO of Blue Iron IP. We're a patent finance company where we'll make 50 to 100K investments in startup companies to get them decent patent portfolios. And then we'll do loans against patents at $2 to $5 million for later stage companies that have some revenue. You can find me at blueironip.com. You can pick up my book, Investing in Patents, available on Amazon. We're always looking for new deals to finance and syndication partners with angel or venture firms. And please feel free to get in touch with me. And I look forward to chatting with you.